Good evening to all. Good evening to all. So this is Abhivardhan from Internationalism, and now we are live for a special interview session with Professor Sourabh Ubale. So I will now pass the baton to Vijay Lakshmi so that she can inaugurate the session and pass on from a formal introduction. So thank you so much. Vijay Lakshmi, you can go on.
Thank you, Abhi. Good evening, everyone. I, Vijay Lakshmi Raju, Associate Editor of Linked by Internationalism with Mr. Vaibhav Dwivedi, welcome you all to our today's session. We have Professor Mr. Sourabh Ubale with us as an honorable speaker of this session. Professor is a PhD scholar in law from University of Mumbai on Kautilya's Arthashastra. He completed his bachelor's in law and master's in international law from Savitribai Phule University with an outstanding grade. Professor holds various diplomas. He is a teaching associate at Department of Law and Human Rights Education Program at Savitribai Phule University, and Professor has also given teaching assistance in various subjects of law. Professor represented India in various events. He has also published several research papers and articles in international and national journals, conference proceedings, as well as chapters in books and monographs, and working as editor of journal and books. We are enlightened to having this great personality among us in today's session. We are going to discuss about the topic of traditional justice in relation with deterrent theory. We welcome you, sir.
Thank you, Vijay Lakshmi.
I now request Mr. Vaibhav Dwivedi to start with the questionnaire part.
Question is after the session. I will request sir to begin the session.
Yeah, sure. Okay. Hello to everybody. As a difficult task to handle a subject which has various nuances, like for example, when we start reading out about the traditional justice, it includes both the words justice as well as traditional. Okay. Now, in the contemporary approach, we already studied that how that particular traditional justice being transferred to the transitional justice, and then in some of the countries we also can find the hybrid justice in that context as well. In addition to these words, we also have two important words in this, and that is the deterrent theory or deterrence theory. Now, again, in the deterrence theory, we have two important words, deterrence as well as the theory, okay? Because here we are talking about something which is there from a jurisprudential point of view, or some of the philosophical points of view are associated with that particular subject matter. In the same time, we also are talking about the deterrence or to deter. So as a human being, you already know that, what to do, what do you mean by that, the word deter. So basically, when we talk about evolution or historical background regarding this particular context, I wish to start with a concept of administration of justice. Or before that, we can see that it was the role of the state authority. That basically two important functions that we usually say when we talk about the state authorities. And one is war, and second one is an administration of justice. Now, when we talk about an administration of justice, the word justice is there, and administration of that word is being given with the state authorities. Now, when we talk about again the war, again we'll keep war aside, because now for today's discussion, we just focus more upon the administration of justice. Now, in the context of administration of justice, now justice may not be same to each and every person. Okay, so justice and the concept of justice may vary depending upon person to person. We usually say that deterrent theory is associated, or the theory of punishments are associated with the civil justice or criminal justice in that context, or administration of civil justice and administration of criminal justice. But basically, when we talk about the punishment, we more focus upon the criminal justice system. But is it so that only in criminal justice system we have the punishments? No, I mean, we already have seen in the evolution of the jurisprudence as well as evolution of the judicial system and the precedents and n number of things. We know that whenever we talk about criminal administration or civil administration, we know that in both of the cases, punishment can be given. Now here we are now going to we are trying to correlate that particular context in respect with what that we have called as contemporary approach. Because whenever we say that no, we have to punish any particular individual, we have to find out why we have to punish. The best important thing that I in this context need to focus is that no, it is just not that we are going to punish any one particular individual. No, we have to take into consideration all the important elements, like why we have to punish, how we have to punish, and when we have to punish is also one of the important points. So whenever we are asked all the WH questions to that particular punishment, we'll get number of answers in that context. Now let us try to correlate it with an ancient Indian system that we had. As the Vijayalakshmi rightly pointed out that I'm doing my PhD in the Kautilya's Arthashastra, and if you read out the Kautilya's Arthashastra, we have a separate chapter of Kautilya's Arthashastra. Now see, when we were talking about the natural law, or when we're talking about the positivist approach, the law given by the sovereign authority, we during that point of time had the positive law, the written law in the form of Kautilya's Arthashastra. Even if you try to read out the Manusmriti or n number of ancient literature, irrespective of the religion, then in all the ancient literature we will find that the concept of punishment is very much there. And in that context, we also can find the deterrent punishment was basically focused more upon. And even in a latter part, I mean, if you take an example of Queen Elizabeth, she also is of the opinion that the deterrent punishment shall be given. And so that's why here the importance of deterrent punishment or deterrent theory is to be focused in context with now the justice system. Okay. Now, whenever we talk about Kautilya's Arthashastra, as we know, we have the administration of criminal justice, which has been incorporated by Kautilya's Arthashastra, incorporated in Arthashastra by Kautilya, and we can see that in n number of cases, he focused upon giving the punishment in such a way that we can deter the individuals as well as to society at large, so that at the time when we consider society, we shall have the peaceful society at every point of time. And so that's why, as no, at the starting point, I said that there are two functions of the state authority: war and administration of justice. And in both of the contexts, states' responsibility is only one thing that they have to do, and that is to keep peace and tranquility in the society, within that particular society. And so that's why this gives one more role to the state authority, that is role of dispute resolution. Okay. Now let us try to discuss that dispute resolution in context with the justice, the system of justice. Now we here talk about the traditional justice, or then the transitional justice, or then the hybrid justice. Now, what do you mean by justice? That we already know that we just try to reveal the truth behind it, try to find out some evidence, and try to make the solution on the disputes which has been there within the society. We know at the evolution point of the society, we had this justice system, but we didn't have the judicial system to discuss this resolution of justice. And probably that's why we can trace the history of traditional justice from that point of view, where we had this particular element that we didn't have any particular legal principle, or say we just had a social contract, or before to the social contract as well. We tried to resolve the dispute in between the individuals. It's basically by giving, or by having a fight in between the individuals and asking the relatives to come. Now, this is the point where we're talking about the primitive society. Now, consider the today's situation. We still can find the same system of justice, where here we're talking about the system of justice to be implemented by individual, or to be implemented by handful people, instead of going into the judicial authorities. Now see, if there is a fight in between the individuals, consider that there is a remote location, there's one village, and there is a fight in between two individuals. Now it may happen today as well, that one of the individual may ask his relatives to come, and another individual also ask his relatives to come, and they can start, they'll start fighting with each other. Now this is how they started creating the deterrence to the another individual. Okay, so for example, if you try to violate my right, or if you try to no no try to do something which shall not be done in a normal course of or due course of time, if you are doing so, then we are going to give punishment by ourselves. Okay, so this is how no, in a contemporary era also, as well as in the primitive society also, we can see this administration of the criminal justice. Okay, and so that's why probably this concept of deterrence been created during that point of time. Now this is again a huge study made by different jurists, especially when we talk about the jurist Salmon or Bentham. No, they focus more upon the deterrent approach, because they think that when you try to deter or to try to create some example in the society, so that the individuals, after seeing this particular example, shall restrain themselves by committing any particular crime. So basically, the theory of deterrence, traditional justice system, is directly proportional to this particular context. Now let us try to find out the nuances of the deterrent theory. Now, before going to again to deterrent theory, one more important point regarding the justice is when we talk about the traditional justice, it also includes the justice at a grassroots level, justice through panchayat system, khap panchayats again can also be one of the component of the traditional justice. If you read n number of the researches regarding the traditional justice system, you can find that in various locations, especially with the African region, you can find that there are traditional justice through the community system. So they probably make one particular community code like system, and then through that community code they try to give justice to the individuals of that particular community. Now, this may have a reference to that the concept of justice, as we say that it may be different to different number of people in the society. Now, let us move to some part of the deterrent theory. Now, as you know, that Salmon rightly pointed out that the chief aim of the law itself is to make the wrongdoer, to punish the wrongdoer, or to make that wrongdoer as an example or warning to the other individuals, so that other individuals shall not commit that particular crime or shall not commit any crime. Now, see here, I'm using the word shall not commit that particular crime or shall not commit any crime. So this gives again one important point, that we can say that deterrent theory can be divided into specific and general. Okay, now what is the specific and general? If you read some more research papers, you'll find that there is one more important element associated with the deterrence theory, and that is the incapacitation. So basically, some say that this includes in the deterrent theory. Some jurists are of the opinion that we shall not consider it under the deterrent theory. But let's see that how it is having its relevance in any of the parameters, on any of the parameters of the theory of justice. Now, when we talk about the deterrent theory, it's specific and general. Now, when we say specific, it's basically it is to restrain other individuals not committing one particular specific crimes. For example, now say pickpocketers. Now here we cannot give them the deterrent punishment, but we shall give such kind of punishment to them that they also shall restrain themselves from doing that crime again. And we can say that this is an example, that this is a warning to the other individuals as well. And so this is a specific deterrence we can consider in that context. We also have a general. So here any crime in that context we can consider under the context of the general deterrence theory. Now, the best example here we can take that, see why the deterrence is important, or in some of the contexts that we can also discuss through this example. Now we know that obeying the traffic rules, right? So why I'm saying the obeying of the traffic rules is important, because we know that we need peaceful society. We shall not have any accidents on the road. Our behavior shall not no, violate the peace of the society or harm to any other individual. Okay, and this is in jurisprudential perspective is one of the criteria that no, we have to presume this in the society. So you must have read the Roscoe Pound's postulate, jural postulates. Here we have to assume that no one is going to intervene into your matters or going to harm you. Okay, now this is one thing. Now see, if everyone is trying to obey this particular rule, or all the traffic rules, then there won't be, so there is no need to have any traffic police in the at the signals. Okay, but still we have to have the traffic signals. Why? Because we know that here we can escape from that particular signal if the police officer is not there. And so it means that, okay, this thing is not to be done by each and every individual. Okay, some of the people say they are going to commit this particular thing. Okay, but after seeing that this particular person is violating the signal rule, and still he is not, no, so there's no punishment to that particular individual, may again, no, see, I'm just going other way around. Okay, so after seeing this person escaping from the legal rules, I can tempt also to violate that particular rule, that signal. Okay, and this may create again the chaos in the society. Okay, this is one of the thing. Secondly, now see, you can also see the cameras installed at the signals. Okay, and now they're coming with the system that if you jump the signal, red signal, then they usually capture the image of your number plate, and then they usually send the fine receipt, or the fine they usually charge, and they can send it to your respective home, and then we have to pay that particular charge. Unless we pay it, then they usually ask, they usually put the interest on it as well. Okay, now this is the thing. Now here, though in that, now this is the situation where I can consider that no, there is no police officer in the at the signal, and so I restrain still, because I can see that there are cameras, and so here I know that the chances of getting caught at that point of time is higher, and so that's why I may not indulge into jumping the signal. Now see, this is how we have to correlate it with the aspects of the deterrence theory afterwards. Okay, so we'll keep here in this context the same thing, and we'll then again revert it back after some point of time. Now we know that whenever deterrence theory has been considered, a lot of opinion in the world that no, we shall not go into the deterrent theory, or deterrent punishment shall not be inflicted, only because no, we also have to consider the human rights. Okay, now yes, it is true that no, as a human being we shall not. Okay, so for example, one of the punishment we can consider that hanging before the public at large. So no, this if considered the punishment, then probably it may have some negative effects on the society as well. Okay, now while discussing this particular topic, we also have to focus upon the criminal psychology of individuals. Okay, not only I'm talking about the criminals, but individuals at large. Okay, because now see, though there are deterrent theories, okay, I shall quote the United Nations thing that no, they say that uh, death penalty, though it is there, but it is seen in the society that there is no decrease in the crime rate, though there is a death penalty for some specific offenses. Okay, now this is again a true sentence or a true statement, and we can see that though there are deterrent sentences, though there is a death penalty to some of the specific offenses, but still the crime rate regarding that offenses is not decreasing. Okay, now that's why we have to consider it in some different manners. Okay, so we have to consider some positive aspects and negative aspects as well. Okay, now let us move ahead. I just wanted to again focus upon the deterrence theory, and now the most important element I shall tell you, because I can see that a lot of students studying the law are the part of this particular lecture. And so we always can find a lot of memes on the internet regarding why we have to study the jurisprudential perspective or jurisprudence in that context. But we know that this is where we can find n number of things in the jurisprudence to get the solutions of the problems that we have now. And so that's why again it was one of the part of my thesis as well. So whenever we talk about the punishments, we also have to think okay, because that's why I said in the starting point that we have used the word theory as well, also one of the components. So we have to analyze the theory and get into the exact implementation of those theories wherever it is possible. Okay, now let us in that context we'll go ahead with the theory. Okay, now we know that in the deterrent theory, you know that we have a lot of work given by the Bentham. Bentham in probably 1764, I guess, has mentioned in one of the paper that no, we shall have the theory of the deterrence, or there shall be deterrent punishments to the criminals. And so that's why he said that there shall be three important elements to be considered while considering the punishment section or punishment part of any particular offense or crime. So he said that there are three important elements. The first element that he said that is a severity. Okay, so severity of the punishment shall also one of the important aspect to be understood. Secondly, he focused upon the certainty. Okay, so certainty again is associated with the judicial system, with the police system, or with the executionary machinery as well. Okay, that we'll discuss in a later stage. And the third thing is that he was talking about is the celerity of that particular punishment. Okay, now celerity is kind of swiftness. Okay, fast things. So what is the serenity? Now, for example, now consider consider that there is one particular crime, heinous crime we can consider, and if we think that okay, now the case is before the court of law, and if that court is taking too much time to settle that particular matter, to give the to find out who is culprit and to give the punishment, then probably it lose some faith in the system as well. Okay, now again, if we consider the pendency of the cases in the courts, then again it is not possible to the human being. I mean, because judges are also human beings, so they cannot no. So that's why their we can say their burden we can see, and so it is also for them also it is not possible to give judgments as soon as possible when the case is there in the before the court of law. And so that's why this is kind of again we have one more issue regarding vacancies with the judicial authorities. Okay, now here we are not just talking about what is wrong with it or with the system, but we are trying to make it simple, in a simple way, that no, in which context we can implement those deterrent theory in the practical approach to impart the justice to the society at large. Now let us try to understand this particular context that is given by the Bentham, like severity. So we know that no, again each and every point has both of the perspectives. Now when we talk about the severity, we know that the severe punishments to be considered in the deterrent theory, and severe punishment shall be given. Now consider one of the severe punishment, death penalty. Okay, now we are not just going to focus more upon death penalty because it's one of the part of the deterrent theory, and we know that many of the nations, they have abolished the death sentence, but still some of the countries still give death sentence as a part of the deterrent theory. But here in this context, as I said, that no, we also have to check out the psychological perspective of this theory as well, or of this death sentence as well. One of the national law universities, they've made excellent research on this. Okay, so you can try to read out that research regarding the death penalty. And so in that context, if you read the context of the psychology in the relation with the deterrent theory, you will see that it may become because there is a delay in the execution as well, is one of the problem that we also have. We also have the problems with the with the administration, the prison administration, because we know that as a huge number of criminals, and we have more than the capacity that we are that the criminals are there in that prison. And so see, in this particular platform we have to find out that solution, so that maximum of these problems can be curtailed with minimum friction, like we say with the Roscoe social engineering theory. Okay, so we have to balance the interest of all the individuals in the society. So is that mean that when we give severe punishment, then the rate of the crime is going to reduce? Probably yes, probably no. Okay, because it may happen that because of the severe punishment, and if there is a prolongment of the severe punishment, no, there is no really any output on the society as well as on the individual at large when we talk about it. Second important element given by the Bentham is the certainty. Now, when we talk about the certainty of getting caught while doing that crime is also the most important part in the deterrent theory, where, because when you read out the criticism of deterrent theory, you realize that certainty plays an important role. Okay, even not only by the Bentham, but one of the paper published in 2000 by Daniel N. Also suggests us that how the mathematical formulas and how economic formulas can be built up to find out how it has impact on the society at large. Okay. Now consider that the same case that we already have discussed regarding the jumping of the signal. So if there is a fear of getting catch hold by the police officers or by the authorities while doing that particular crime, then probably that is going to create some impact on the society at large or individual at large. And so that's why certainty shall be there. Now we know in the context of certainty that how many cases or how many crimes been there in the police diary, how many been acquitted, how many convicted because of this particular situation, right? And so the rate of this particular conviction is very low in context with the crimes that we have. Okay, and because of that, maybe people are getting escaped from the picture of the peaceful society, picture of the law or law-abiding society. Okay, uh, I think various people are basically during this particular period are watching a number of things on the Netflix, on Amazon, on a number of platforms. In one of the series I saw that the person is usually hiding his identity doing the crime, or in doing the phone calls or video calls, or he's basically using some of the applications so that his voice shall not be identified. Now this is how, if it seems that the person is been unable to catch the people, the administrative authorities are unable to catch that particular person in this context, catch that particular culprit in this context, there may be a rise in the or increase in the crime rate as well. Okay, the last thing that we already discussed, that celerity, where the swiftness is also important in that context. Okay, now before coming to the question answer session, I also have to focus upon one of the report being produced by some agencies in the United States Department of Justice, and they also have the opinion that there are 5 things which are important about the deterrence. While discussing about those things, they say that the certainty of thought is a vastly more powerful deterrent than the punishment. So instead of focusing upon the punishment, we have to, because see, ultimate aim of the law or ultimate aim of the punishment is not to inflict some thing on the culprit or on that particular offender, or on that isn't a very effective way to deter a crime. Because sometimes it may have seen by you as well, after reading out some reports or after watching some of the documentaries, that when a person, if you put him behind the bars, then probably there in the prison there are higher chances of getting much more lessons of doing the crime in different ways by from the inmates. And so that's why this is how, in that context also, deterrent theory may fail to create a deterrence in the society at large. So sending an individual convicted of a crime to prison is not much very effective in that context. The third thing that the report wanted to say is regarding the police that deter the crime by increasing the perception that criminals will be caught and punished. Okay, and so here comes the role of the executive machineries. Now again, we know that the burden that the police officers have in the developing countries, overall in all the countries, even in developed countries as well, is huge. And so whenever the police officers, the police mechanism try to caught him in that context of the crime, and then when that particular person has been produced before the court of law, and when the case starts, and when there is again arguments, and then when there is a final judgment by the court, we can see that no, within this particular process, we have n number of things which are affecting the final conviction of the actual criminal or the wrongdoer, right? And so that's why no, the training to the police officers in that context, though it is important, but again we have to see the burden that they have. Okay, and so again we have to balance the friction between their burden as well as the training, because it may seem that no, when the no, we said that IO officer is there in the court, then his statements, investigating officer statement, is also one of the important point to prove that person who proved that accused as a culprit beyond a reasonable doubt. And so in that context also plays the police machinery plays an important role. Then the fourth important element that the report wanted to focus is regarding the increasing the severity of the punishment, again also does little to deter the crime. And so it is not going to deter a lot of or create a lot of deterrence, but a little deterrence. Now see, two approaches can be seen in this context. First, if you again we can say with the various administrative systems, that we can in some of the countries can see the sentence has been given, say for example 30 years, 40 years, 50 years, 60 years, 70 years. Okay, now see, whether giving this particular span as in punishment or behind bars is also can be considered as the part of the deterrent theory, because it is how the people are going to be deterred, because they can see that no, these are the punishments that they have. But if we consider in some of the countries that the punishment may not be exceeded beyond 15 years, beyond 20 years, or in some in that context, then in that case we can see that no, the person who is doing or committing that particular crime may become a hardened criminal in that context. Okay, and so the see, both the perspectives are there. One, that particular person can become a hardened criminal, or can take a lesson from this and can restrain himself by doing that particular crime as well. Okay. Then the thing is, the fifth important element that the report wanted to focus is there is no proof that the death penalty deters the criminals. As I said, that the United Nations also state that there is no proof that the death penalty deters the criminal. But again, in some of the context, we cannot say that it is going to deter each and every individual in the society, but it is probably going to deter some individuals in the society at large. Again, the psychological perspective. I was discussing with one of my colleagues regarding this, and no, we were of the opinion that, for example, we can take the example of one of the terrorists. No, we have convicted him, and we made the execution of the death penalty of that particular terrorist. Okay, now consider that instead of giving him the punishment, we might have, or we could have done that. We can change his mind. We could have changed his mind, and then we could have sent him back to his home, so that he can again become a good citizen. So see, the person who is indulged into such kind of crimes, now we also have to study the psychology of such individuals. Okay, so in that case we cannot say that the no here we shall go for any other type of theory or any other kind of the punishment instead of the death penalty and instead of the deterrent punishments. Okay, and so basically if you try to find out the evolution of all these cases, we can see that in n number of cases we can focus that when there is a waging war against the nation, or when there is a heinous crime, or when there is a crime which is of such nature that we shall go for the punishment, deterrent punishment, then only usually the judicial authorities go for this particular punishment. So this is one of the things that I wanted to share. Coming down to the concluding remark of this particular lecture is that whenever we talk about the law, why we have to make the law is basically, as we know, that the aim of the law is two important things: is to have the peace in the society and to resolve the dispute within the individuals. Okay, and so that's why we come up with the administration of the justice system. Whenever we say there shall be faith in that particular society, in that particular law, in that particular system that we have, and we can have that faith. So for example, if you try to find out that whether the society or the individuals of the society are having the faith in the judicial system or not, then you get probably a huge response. Some are saying yes, some are saying no. I recently have read one of the article in reputed newspapers in the month of January regarding the faith in the judicial system. That they said that it is no the people are losing the faith because probably there are n number of the factors associated with this. Okay, but if you try to find out the factors, we can find out the solution on those factors by having this application of considering the theory of deterrence in some different perspectives, not only from the perspective of punishing them with the higher or severe punishment, but also we have to work on these three parameters given by the Bentham in 1764, that is severity, certainty, and the celerity as well. Okay, and so now coming down to the last line of the justice system, that is traditional justice, the community may resolve their dispute by using this deterrence theory, probably because that may create or that may reduce the burden of the cases in the court of law. But again, we know that whenever it comes to the criminal cases, we cannot use the straight jacket formula to have the settlement of the issues. And so that's why in that context we have to work, we have to research again in that context. And as a law student, we also have to study this particular context, because ultimate aim that we are there as an advocate or as an academician or as a researcher is to have such kind of positive aspects to be implemented in the society at large, so that we cannot create any nuisance or create any disturbance within the society. And no, we can see that not every person or not more than 50% individuals in the society are having the criminal mind, but there are very few. And so that's why, though we need to treat them, but we also have to see in the futuristic approach, considering the technological advancements that we have, because the cybercrime also comes into picture, and the jurisdiction issues regarding the cyber crimes, because we have no we can consider the world as a flattened world, because we get easily have its effect, because a person sitting in another country may hack your system and can do n number of the economic crimes as well. And so we have to implement those kind of perspectives in the newer context of the deterrence theory. So I rest my information or lecture here, and now we can move ahead with the question answer session to be taken by Mr. Vaibhav.
Thank you, sir. I'm beginning with the question I have. Here's the first. Can we think of bringing back the deterrent theory to strengthen the administration of justice?
Vaibhav, I think maybe there's a glitch. If you wish, you can take the second question. Vijay, if you wish, you can start with the first question. And meanwhile, Vaibhav, you can just come in being because I think there is a little network issue. So, you can just rectify and rejoin and Vijay can begin. Okay? Yeah, thank
Yeah.
you.
So, Professor, my first question to you is, does traditional justice require a transition? If so, how?
Okay. Definitely, traditional justice requires transition, but we can say that not in all the cases. So, for example, we can consider that some of the communities they have their own rules and regulations in that context. Okay, consider there are some indigenous or the tribal community where they need their own rules and regulations, and they usually implement those rules and regulations. Okay, now, in that context, we cannot ask them to easily go ahead with the transitional justice. So, here we can focus upon the traditional justice. Or in the similar context, when we talk about the panchayat system, here we can also focus transitional justice as well as traditional justice, so that to reduce the burden over the judicial authorities. Because again, I say that ultimate aim is to settle the dispute as soon as possible, so that we can have a better effect or impact in the society at large in that context.
Great. Vaibhav, would you like to proceed with the question if you're available? I guess. Yeah.
Am I audible?
Yes, yes. Go ahead, Vaibhav.
Can I begin with the second question? So here is can we think of bringing back the deterrent theory to strengthen the administration?
Okay. I think maybe there's a glitch. So in that scenario, Vijayalakshmi, if you wish, you can continue with the questions. And so that the session goes on. I'll just connect with Abba if there's any discrepancy. Thank you.
Okay, okay. So, sir, my second question is, can we think bringing back the deterrent theory to strengthen the administration of justice?
Okay, nice question. Now, when we talk about the deterrence theory, as I already said that we have to think from these three perspectives. Okay, it is very much important because we also can again get back to deterrent theory, so that we can have a very much peace in the society at large. Okay, but now while giving the approach of the contemporary era or modernization or privatization to context with, in the context with deterrence theory, we also have to think the modern perspective of the severity or the certainty or the celerity of that punishment. Here I would like to explain with an example of the white collar crime. Okay, and now consider that a person indulged into white collar crime. Now, when you talk about white collar crime, you know that the people, their economic background and the punishment, if it is been inflicted on them, is of such nature that okay, consider the forfeiture of the property in that context. Okay, in some of the research papers, they create, even in Kautilya's Arthashastra, they considered forfeiture of the property as one of the important part of the deterrent theory. Now, in this context, if we try to implement this particular context in white collar crime, it may happen that even we can curb the white collar crime or probably the corruption in that context as well. Okay, because each and every wrong, though it may be civil wrong or maybe the criminal wrong, we have to understand it from the perspective of curbing the crime and not from the perspective of giving the punishment to the individuals at large. Okay, now individual, if it has been given such kind of punishment of which is of the nature of the deterrence, then probably it may happen that it may create, okay, again it's a it's kind of R&D that we also have to do with the contemporary approach, as they did with the probably from 1960 till now regarding the deterrence theory, especially when I talk about the Daniel N's paper. That's why we have to create an experiment in the society at large in a better manner, so that we can get again back to the deterrent theory in that context. In some of the cases, deterrent punishments are not important or not to be given. So probably when you read the ancient context, you can see that even the pickpocketers, they were punished with they I mean there are some punishments to the pickpocketers, cutting their hands, etc. And so considering the nature of the crime now in a modern context, we may not find this with all the crimes, but we still have to think of the deterrent theory for at least some of the crimes, because unless we focus on it, we cannot reduce the crime. I think so. I mean, as per my opinion, when I studied that those many reports, I come to conclusion that yes, we still need a deterrent theory to have the peace in the society at large. Over to Vijay Lakshmi.
Okay, thank you, sir. My next question is, where does India stand when it comes to deterrent theory and traditional justice?
Okay, nice. Now, Indian context, when we talk about, we know that India has yet not abolished the death penalty. Okay, even when we talk about administration of the prison, we know that basically generally 14 years is an administrative part of the prison, as we know. Then the CRPC has been provided also is the maximum punishment that generally we can consider. And so in that context, we have to think that in different kind of cases you might have learned given by the Supreme Court. The court also said that the ultimate aim of the judiciary, the Supreme Court said that ultimate aim of the judiciary is not to again give the punishments to the individuals at large, but it has to create some positive impact in the society or negative impact to the like-minded people. Giving the punishment, the court also said that instead of giving the punishment, we also have to think of the rights of an individual. We shall not, okay. So they, in one of the case, the Supreme Court said that no, we usually have the punishment with rigorous imprisonment for some period. Now, rigorous imprisonment also have to be defined because we cannot put them to work for number of hours because we have to deter them, right? And so in an Indian context, yes, we follow some part of the deterrent theory, but as we know that on these three parameters, we somehow fail because when it comes to the certainty, then the system that we have or the technological advancement that we have are lacking behind to caught that particular individual. So that's why maybe we can think from that perspective in an Indian context to implement the deterrent theory.
Great. Vaibhav, you're there?
Yes.
Okay. Can the volume be extended a little if possible? Yeah?
Yes.
A little, if you're not near the
This
mic.
is the maximum. This is the maximum.
Okay, go on. Sir, I think now Vaibhav can do it. Yeah.
Yes, sure.
So here's the question: what are the impacts of traditional justice in deterrent theory?
Okay. Okay.
I think Vijay Lakshmi can repeat the question if she heard.
Yes, sir.
Yeah.
So, what are the impacts of traditional justice and deterrent theory in other countries?
Okay. Yes. Now I shall quote two important countries in this context. The African region as well as the Indonesian Indonesia. When I come across with some of their reports, I can see that the deterrent theory is playing important role in a traditional justice system because we know. So, for example, if I'm a person and I'm a human being, so I have to be the part of the society at large. And so when I'm the part of the society, I have to think that what are the rules and regulations of the society, because I cannot live without the society, I mean the general context. And so that's why if the society thinks that this particular thing shall not be done by this individual as well as the other individuals from the society, then probably that may create some fear within the society, within that particular community, or within the group of the people. And so that's why they found that because of the deterrence theory, the traditional justice system is playing an important role. I mean, in both perspectives, vice versa, both are impacting on each other. Here I would like to quote the example of the Saudi Arabia or some countries in the vicinity. Now we know that if we consider any other country, we cannot keep the doors open, can sleep, or we cannot keep our doors open of say consider the jewelry shop, okay, but it can happen in the countries like this, okay. So why it is so? Because ultimate, though we say that we shall not have the deterrent theory in maximum context, but we know that when the deterrent theory is prevailing in such countries like Saudi Arabia, in some of the countries, the crime rate of those countries been very low. I mean, this thing we cannot deny in that context. And so though may they have a very severe punishment in some of the contexts, but still it is going to create a law-abiding citizen at large. And so wherever any other person goes into their country, no, they also have that particular in their mind that no, here we are safe because here is the society where the law-abiding citizens are there, and it is not because the people only are thinking of having a good behavior, but here the society and the state is of such nature that they are creating so much impact on the legal system, so that people shall they are restraining themselves by doing any type of crime in that context. So this is in general context.
Okay, sir. Uh, what are the possible ways to make speedy disposal of cases when it comes to traditional justice system?
Okay, great. Now, basically, I think we have to focus more upon the process. Okay, because when so when this particular problem comes into Vijayalakshmi's mind, probably she had no the picture of all the whole process that has been followed from the commission of the crime till the disposal of the matter. And so the problem lies with the process, because whenever we say this is a problem, we have to find out where the problem lies. In one of the research I have studied that no, in that context we have to say that why punishment shall be given, and what is the what is the purpose of giving that particular punishment to the individual. Okay, now when we talk about the process, we can easily go ahead with the speedy disposal. Now this is not again, I mean, we know we all have the answers to this question, probably starting with the pendency of the cases. So the judicial authority shall see into it. Then we have to fill all the vacancies of the judicial officers. We have to train the executive officers. No, these are the solutions that we have in general. But again, we have to go beyond it, because now we have the huge technological developments, and in that context we can use, now see, unless we had this situation of this COVID-19 or the lockdown, we could not have implemented the online mechanism with the judicial authorities, because I can see now all the lower courts are focusing more upon the online filing of the cases, petitions, online arguments through this particular thing. So no, this is how the jurisprudence is. I mean, unless we come across any particular problem, we usually do not focus upon the solution. So instead of that, we shall try to think of the future problem and start implementing it. It might have happened that in the last year we could have implemented the online system of the arguments through the online portals, or filing of the cases through online portals. But no, it made this particular situation that made us to think of this particular perspective. And so that's why in that context we have to think of curbing in Indian context this particular phenomenon with the use of the deterrent theory.
So my next question is, does capital punishment follow the principle, more severe the punishment, lesser the crime?
Okay. Actually, as per my opinion, is no. because I wish to go with the wordings of the United Nations that death penalty has not yet reduced the crime rate of that particular crime. Okay, now see that when now we have to think from this perspective that we have to find out the crimes on which we usually go ahead with the death penalty. Okay, now waging of the war is again the most important element from any country's perspective, because the sovereignty shall prevail and the status shall prevail. Now let us move not from that perspective. Let us move to the other important crimes against the property or against the offenses against the human body. We'll see that in some of the cases where we can see that this is particularly a very heinous crime, or we can say that this particular crime has a bad impact, extremely bad impact on the society. Then only we usually go for the death penalty. Okay, now as I said that death penalty shall not be considered as one of the most important point in this context. Why? Because giving the death penalty, yes, it is not reducing the crime, but as she rightly pointed out, Vijay Lakshmi, that the process, if you focus, if you curtail the process, then may have its impact in a positive sense. But still, uh, death penalty, if we are implementing in the society, it may happen that maybe some group of the individuals also may have the positive impact upon them. Okay, I can give an example with a very general understanding of when any particular person indulge into the crime. Okay, so basically when he want to have any particular pleasure, or like pleasure pain theory in the jurisprudence we have studied, or maybe some economic benefits if are there, and thirdly if some psychological issues are with that particular individual. Okay, so if you try to understand these particular elements, then we can say that in these three contexts we can go ahead with the deterrent punishment, and not only the death penalty is going to curb the percentage, or the are not going to reduce the crime rate in that context.
Thank you, sir. And my next question to you is, did abolition of jury trials lead to less conviction of crime? Nexus between jury trial and deterrent theory.
Great. I mean, this is the context where we can also think of your favorite movie Rustam, where they have shown you the last case that we had with the jury system. Now, yes. Now, see. Now, here I would like to focus upon the perspectives of the other nations as well. Now, in some of the developing countries, if you try to find out, you can see that they still have the jury system. Okay, and the traditional justice, the evolution of the traditional justice itself can be traced with the jury system as well. Okay, historical background. Now, when we talk about the jury system, we know that the people from the society, they've been elected, and they usually are going to find out the opinion of the things. They are going to see the different perspectives of that particular crime, and how we can how can deal with that crime to get the final solution. Now, see, in both of the perspective again, when the jury system is there, probably it may happen that because of the jury system, uh, cases which are pending at very grassroots level can be curtailed or can be resolved in that context, and that may help to again reduce the burden of the judicial authorities, which are higher judicial authorities, probably maybe the JMFC, CJJD we can consider, and above them. But again, in the second context, it may hamper the process at large, because see, I believe in the legal system, I believe in the judicial authorities, because I think that this is the system where they can see this particular thing neutrally, and depending upon the laws that we have, they are going to try the case. But when my matter goes to the jury trial, it may happen in my mind that no, if I'm no, these are the people who no, not all the jury people are having the background of the law. And if I'm having no, my crime been decided by these particular people, then probably I may not get justice. So see, this is the faith that is that varies from the actual judicial system and the jury system as well. Okay, and so on this parameter, if we could work from research point of view, now again. No, this is again my opinion, because you may think that the jury system is or shall not be there because there are a lot of loopholes in the system. But again, if we can think to the grassroots level implementing this particular system, then probably we have a greater impact on first thing, that is the reduction of the crime rate. Secondly, to have the celerity, because when we say the swiftness shall be there, we can have that at the lower level. Severity and certainty may be in question when we talk about the jury trial, but again we can just go ahead with some permutations and combination, so that in that context also we can think this perspective. I think I like this question the most, because this is how, I mean, probably the people who are more into the research can think from this perspective and can have the Panchayat Raj system, deterrent theory, and the jury system, and they can revisit those particular things again in this context. Over to Vijay Lakshmi.
Thank you, sir. And my next question is, will legalization of prostitution in India put an end to human sex trafficking? Is this an indirect implementation of deterrent theory?
Okay, great. I think people who have read regarding the prostitution, I usually say that in an Indian context, prostitution, whether it is legal or whether it is illegal, I mean, again, is a question. Okay, because though we have the human trafficking enactments, though we have a number of things, but still, whether we can consider the prostitution, or whether we can exactly, or the administrative authorities are going to the brothels and catching them and putting them behind, whether this is happening, no. And so in Indian context, we have we generally follow, we know that we follow the common law country. We know that we follow more upon the moral principles, natural law principles, natural law theory we follow, and so ethics that we follow. And so probably because of this, the question purposefully been kept as unanswered by the authorities, as I think. I mean, now when you talk about the states, like state of Nevada, I guess you can just cross check that they are having very much good system by legalizing the prostitution, and they have made the health facilities, the rest of the economic barriers they have removed, and they have very good conditions of the prostitutes at that point of are there. Now I can understand that particular question in the context with the sexual offenses that happen in number of countries. Now yes, and so as this or legalizing the prostitution cannot ultimately reduce that particular crime rate, we can say, because no, this is one of the factor that we can consider. But again, when we try to say that legalizing the prostitution may reduce the crimes, so still we have one particular element in our mind, that when you legalize something, it means that probably you are getting the license to do that particular thing. And so when you have this approach, then the purpose of the law is defeated in this context. And so that's why while discussing about the prostitution and reduction of the crime rate, sexual offenses crime rate, we have to think this particular perspective from a different angle. So again, a good thing for the researchers to do research into this, because prostitution is the thing where we cannot equate that particular thing with the other social problems that we have, because this is a thing where in an Indian context we have very much ethics, morality attached to this particular issue. And so from that point of view, we can easily find out the solutions if we try to. Right? Over to Vijay Lakshmi.
Thank you, sir. My final question is, was the abolition of jury trials lead to less conviction of crime? The nexus between jury trial and deterrent theory.
Okay. As I already told you that whenever we talk about the jury trial, we can implement the jury trial system at a grassroots level. But again, we can formulate the procedure regarding the individuals to be there on the jury system. Okay. Now, if you try exactly to find out the jury system, yes, we have at the backdrop the judicial authorities as well. But still, when we talk about the group of the people, or group of indigenous people, or group of some people who are having the having the same traditions, etc. So in that context, we can very much try to have the implementation of the jury system. If we try to revisit the jury system again in the context with Bentham's three ingredients of the punishment, as well as the modern context or the modern component of the punishments and the rate of the crime and the crimes that we have in the technological development era.
Thank you, sir.
Great. Thank you so much, sir. Thank you so much, Vijay Lakshmi. And thank you so much, Vaibhav and Arya. I think we really had a great session. So hereby, I conclude this session in 10 seconds. So pardon me. I hope there would be a lot of questions coming. So if there are any comments or questions, we will mail the questions to sir, and I think we can answer it through YouTube chat. But I think it was really an enlightening session for the Legit team. So congratulations to the Legit team, and hereby I end the session. Thank you.